Welcome. We will discuss following topic. International Court, European Court of Justice, ECJ, International Court of Arbitration, ICA, Alternate Dispute Resolution, Islamic Arbitration. Mediation and Conciliation, Unilateral Model on International Commercial Arbitration, Arbitration Agreement and Substantive Claim before Court. B. International Court of Arbitration, ICA. The International Court of Arbitration established by International Chamber of Commerce, ICC, resolves international commercial and business disputes, administering more than half of all arbitration disputes worldwide. It played significant role in the New York Convention of 1958, in which all the states ratifying the treaty agreed not to take disputes to courts in presence of written arbitration agreements. The Court of Arbitration's role lies in providing an organizational framework for the procedures and offer, if necessary, support to arbitrators. It oversees procedures, helps to resolve problems and guarantees the enforcement of awards. Support is granted in French, English, Arab, German, Spanish, Italian, Portuguese, and Russian. Alternate Dispute Resolution. The term, Alternative Dispute Resolution, or ADR, is often used to describe a wide variety of dispute resolution mechanisms that are alternative to full-scale court processes. ADR systems may be generally categorized as negotiation, conciliation, mediation, or arbitration systems. Arbitration. Arbitration is a procedure in which a dispute is submitted, by agreement of the parties, to one or more arbitrators who make a binding decision on the dispute. The solution can be in the form of compensation payment, behavioral change, apology, etc. Islamic arbitration. Arbitration in Islam is called tahkim. Arbitrator is called hakam. Arbitrator must be Muslim, well-versed of Sharia law, and should be able to arbitrate. Mediation and conciliation. Mediation and conciliation systems are very similar in that they interject a third party between the disputants to mediate a specific dispute. Decisions are not legally binding. In Islam, mediation is called wasta and conciliation is called sath. Pros of alternate dispute resolution. Takes far less time to reach a final resolution. Arbitrator of choice, cost of arbitration is low. The parties can also have their dispute arbitrated or mediated by a person who is an expert in the relevant field. UNICITRAL Model on International Commercial Arbitration. The Model Law on International Commercial Arbitration was adopted by United Nations Commission on International Trade Law in 1994. International Commercial Arbitration. International commercial arbitration is a means of resolving disputes arising under international commercial contracts. According to Article 1, arbitration can be categorized as international if parties conduct business in different countries or the business is in the same country but arbitration is designated to be in a different country, and it is commercial if their business is commercial in nature. Law on receipt of written communications. Article 3 states that communication will be deemed to be delivered if it is sent to the addressee personally or at his business or mailing address. If the above are not possible, then written communication sent at the addressee last known place of business would be deemed to be valid. Extent of court intervention. Article 5 states that in matters governed by this law, no court shall intervene except where so provided in this law. Article 6 states that the states which adopt the law should specify the court competent to perform functions such as of appointment of arbitrators, etc. Form of arbitration agreement. Article 7 defines the arbitration agreement as an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. Article 7(2) states that the arbitration agreement shall be in writing. Article 7(3) states agreement is in writing if it is in written form or is referred in legal proceedings and the other party has not denied it, or a written contract between parties makes reference to an arbitration agreement. Arbitration agreement and substantive claim before court. Article 8 states that a matter which is subject to arbitration in terms of arbitration agreement is brought before the court. The court shall refer the same for arbitration unless the arbitration clause is null and void. Article 8(2) arbitral proceedings can be commenced and award can be granted even if the court proceedings have been initiated. Case 57. Composition of arbitral tribunal. Article 10. 1. The parties are free to determine the number of arbitrators. 2. Failing such determination, the number of arbitrators shall be 3. Each party shall appoint one arbitrator within 30 days, and the two appointed arbitrators shall appoint the third arbitrator. Parties can agree upon a sole arbitrator. If the same cannot agree on the choice of person, then the court can be requested to make the appointment. Thank you for watching and listening.